Good morning, ladies and gentlemen. We'll start now. Welcome to this Landmark Chambers webinar. I want a witness, can I get a witness? The new approach to witness evidence post the new practice direction, PD 57AC. We are delighted that there's so many people joining us this morning, and I hope you'll find it stimulating and interesting. To begin with, there's a few housekeeping points to note. First of all, your microphones are automatically muted, so you'll not need to adjust your local settings. Secondly, we very much welcome questions throughout the session, but please submit them via the Q&A section, which we find at the bottom of your screen, or the top, depending on which way you go. We'll endeavour to answer as many questions as possible. We'll try and answer them at the end. But please feel free, if you feel that you've got a question, burning question, please feel free to let us know via the Q&A section. The webinar will be recorded and you'll receive a link to the presentation and the recording shortly after the event concludes. If your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. Hopefully, we'll be able to tell you why it was propounded and what its contents are. We will have, I think, 5 sections in the seminar this morning. You're going to get 3 talks. Then we'll have a brief quiz, in which we ask you to participate, and then we'll have the Q&A session depending upon the time. The 3 speakers, as I hope you will, and the topics are now overview as you see on the screen. First of all, there'll be how to ensure statements comply, the impact on other aspects of trial preparation, and the consequences of the conduct of trials. And what we'll try and tell you about is, first of all, what the motivation behind the new rules is, what the mischief is, and Joel's going to deal with that. Then Evie will take you through the rules themselves, and I will give you some thoughts, such as they are, on how it might impact practically on trials. We have, as I say, 3 speakers today. I am David Holland QC, and if any of the listeners don't know who I am, then it's best that you don't. Secondly, we have Joel Semakula. Joel is one of our newest tenants, having successfully completed his specialist property pupillage last year. He has an interesting backstory. He started off as an investment banker with Morgan Stanley in New York for 2 years. He was a judicial assistant to Lord Justice Gloucester and worked in the global litigation team of an oil major between 2018 and 2019. And away from the law, he also is a dab hand at stand-up comedy. Let's see if he can make the new practice direction funny. Then we have Evie Barden. She's 2014 call. She joined us last year from Enterprise Chambers and is now an integral part of our property team. She has a wide-ranging practice in both residential and commercial property and general chancery litigation, with a particular specialism in insolvency. So if either you or any of your clients are contemplating insolvency, Evie is the person to whom to turn. Right, well, Joel that's all I need to say by way of introduction. Joel is going to kick off. Joel.
Good morning, everybody. So as June 21st is so close, we've tried to incorporate some tech into this and make it not your average Zoom. Just a couple of preliminary points as we think about the tech. Just want to remind everybody that the session is being recorded. In a second, we're going to begin with just a general question, just on the next slide. I'd encourage you, when you do go on to poll EV, that you may want to consider using an alias if you don't want your name to remain in the recording that will be made public. So if we could just go on to the next slide. The first question we'd like to ask you is, which film has the best scene of a witness being demolished in the witness box? 6. You've got 4 options there. If we just go to the next slide. So Legally Blonde, clearly very popular. A Few Good Men. Perhaps nobody's heard of Primal Fear. I personally thought My Cousin Vinny was a pretty good choice. So the answers are coming in thick and fast. So we'll give everybody about 5 more seconds. So if we go to the next slide. So at least within the crowd, the responses are now locked. The general view is Legally Blonde. Now, from the position of the panel, there is, of course, only one correct answer.
Miss Wyndham, what had you done earlier that day?
I got up, got a latte, went to the gym, got a perm, and came home.
Well, you got in the shower?
I believe the witness has made it clear that she was in the shower.
Yes, Your Honor. Miss Wyndham, had you ever gotten a perm before?
Yes,
How many would you say?
2 a year since I was 12. You do the math.
You know, a girl in my sorority, Tracy Marcinko, got a perm once. We all tried to talk her out of it. Curls weren't a good look for her. She didn't have your bone structure. Oh. But thankfully, that same day, she entered the Beta Delta Pi wet t-shirt contest where she was completely hosed down from head to toe.
Objection. Why is this relevant?
Oh, I have a point, I promise.
Then make it.
Yes. Chutney, why is it that Tracy Marcinko's curls were ruined when she got hosed down?
Because they got wet?
Exactly. Because isn't it the first cardinal rule of perm maintenance that you're forbidden to wet your hair for at least 24 hours after getting a perm at the risk of deactivating the ammonium thioglycolate?
Yes.
And wouldn't somebody who's had, say, 30 perms before in their life be well aware of this rule? And if, in fact, you weren't washing your hair, as I suspect you weren't because your curls are still intact, wouldn't you have heard the gunshot? And if, in fact, you had heard the gunshot, Brooke Wyndham wouldn't have had time to hide the gun before you got downstairs, which would mean that you would have had to have found Mrs. Wyndham with a gun in her hand to make your story plausible. Isn't that right?
She's my age. Did she tell you that? How would you feel if your father married someone who was your age?
You, however, had time to hide the gun, didn't you, Chutney? After you shot your father.
I didn't mean to shoot him. I thought it was you walking through the door.
Order, order. Order.
Oh my God.
Oh my God. Oh my God. Bailiff, take the witness into custody where she will be charged for the murder of Hayworth Wyndham. In the matter of the state versus Brooke Wyndham, this case is dismissed. Mrs. Wyndham, you're free to go.
No.
Hell, you know that Chutney was lying. Because she's brilliant, of course.
The rules.
That, of course, reminds me of my first county court trial in practice. A couple of fun facts about that, actually. Elle Wood's first love interest in that film is based off of George W. Bush Jr., and Reese Witherspoon had just had a baby a few days before she started filming that. It seems like the crowd here is well in tune with what the panel's thinking. But perhaps moving on now to the next question. What is the biggest issue with the way witness evidence is used in English trials? And that has now come up. please do feel free to let us know any thoughts you may have. We've all seen the issue of the over-lawyered witness statement. Yeah, sometimes difficult to differentiate between the pleadings and the witness statement. You often see in trials words put to a witness that clearly are not their own words. We've got a whole lot of lawyers on the call who themselves are complaining that witness statements are too over-lawyered. Interesting, we've got the issue of interference. Exactly, again, witnesses not recognizing, witnesses breaking down too often. We'll consider whether or not this practice direction makes any difference. We're going to discuss today the issue of memory and recollection. Great. So, if we could just thank you very much for those responses. So I'm here to just discuss first off, what were some of the problems or the mischief, as David called it, the practice direction was trying to solve. So some of the issues that were perceived by the judges of the commercial court and the users of the business and property courts following surveys and focus groups carried out in 2018 were as follows. The current system of witness statements does not always achieve the best evidence. The working group suggested that the best evidence, in fact, comes from traditional examination in chief, because the evidence is in the witness's own words, as identified by some of the responses earlier, and it's a more genuine version of their recollection. This is in part because the process of preparation of witness statements, particularly in larger cases, the polishing in various iterations results in the final version not being in the witness's own words, those being the words of some of those on the webinar today. The second issue is that witness memories, as described, can be corrupted by developing statements through numerous drafts, such that the last version is less reliable than the first. The third is that witnesses are defensive from the outset of trial, which I'm sure we've all seen, because they're thrown straight into cross-examination, and the cross-examiner is given ability to skew the oral evidence before the court, often because of skill and or time, such that important parts of the evidential case often do not come across at trial. The fourth is that many practitioners do not have any experience of examination in chief, so have no knowledge of the proper and sensible scope of it in order to proof witnesses and draw up statements. Further, statements in court guides that the evidence should be what would be given in chief generally have limited practical utility. Witness statements often, the fifth is that witness statements often stray far beyond what the witness would in fact have said in chief. The sixth is the issue, therefore, is that cross-examination often takes longer than it needs to, because of the ground that cross-examiners either feel or fear, perhaps more likely, that they have to cover. Obviously, as counsel, our fear really of being told that we failed to put something to the witness. And the final one here is that witness statements, the witness statements phase of the pre-trial process has now become time-consuming and interesting, a point we'll address later, resulting what the group found resulting in increased costs and time in the pre-trial timetable. Effectively, the issue was that only 6% of those surveyed thought that the current system of witness statement achieved their purpose of providing the best evidence to the court. That said, of that survey, there's only about 932 participants, and I think I'll ask you, with very few of those were actually solicitors. So the next question we have for you is what would you change about the way witness evidence is used in English trials? we'd love to hear any thoughts from you, and perhaps see if you can beat what we have here in the practice direction. So unsurprisingly, generally everybody wants shorter statements. The role of chronologies, I think, is something that David may cover, but some want those gone. Scrapping them completely, I can't promise that in this practice direction, and less lawyer involvement, which obviously tracks from what we started with. So thank you very much for those responses. Evidently we want to save costs, and we want the witnesses to be using their own words. But in terms of what the practice direction is actually aiming to achieve, so after the survey was carried out, the report produced made clear that there was no appetite for radical reform. So there's going to be no scrapping of witness statements, but it did make a number of proposals for report which have been endorsed by the Lord Chancellor. Now, because of generally the document-heavy nature of litigation in the business and property courts, the need for and importance of factual evidence at trial should have diminished. Narrative is generally documented comprehensively in contemporary documents. It has to be remembered that there is a distinction between limited and formal factual evidence needed to put documentary material into evidence. Genuine factual witness testimony add into the documentary record and comment upon the documents or what the court should make of them. So really effectively, the hopes and dreams of the practice direction was to strip the nature of witness statements back to a few things. First, back to evidence which is required purely to resolve the issues in dispute at trial. Second, stripping it back to what the witness could actually have given if their evidence was taken by oral evidence in chief, which many of us have never actually seen. The point is that witnesses should not be giving long, detailed records of factual evidence reconstructed from the documents. It should be matters which they have personally witnessed or experienced or internal to their own minds. It can include things said to the witnesses. And finally, witness evidence needs to be in the witness's own words rather than something that lawyers have put together, often from the documents, and which has been polished and then signed off. Now I'd like Evie to talk to us about what the practice direction actually says.
Thank you, Joel. So the first question is, who does it apply to? What cases does it apply to? And that's all cases in the business and property courts. There are some exclusions which I'll briefly cover off in a minute, but for property litigators, it's going to probably apply to most of your cases, including those in central London. That's because the Central London County Court is going to adopt the practice direction in an annex to its guide. His Honour Judge Monty confirmed that recently in a talk to the Chancery Bar Association. It also applies to district registries of the business and property court. So even if you're not litigating in London, you need to be mindful of the provisions of the practice direction. It's only for trial witness statements, so you don't need to worry about it for applications, but you do need to think about its application if you are doing witness evidence in a Part 8 claim. That's expressly set out in the practice direction. And I think David will address when he talks about some of the practical issues how it will play out in Part 8 claims as far as we're aware. It's only for trial witness statements, however, which are signed on or after the 6th of April, but that is including in proceedings which started before that date. It applies where the witness statement is made by a litigant in person, as well as those represented by solicitors and counsel, albeit that there are some nuances in its application to litigants in person, and I'll pick up on those in a few moments. So the main exceptions, you'll have to delve into the practice direction in a little bit more detail to exactly find its operation, but are insolvency claims, certain banking and insurance claims, certain claims under the Companies Act, and claims under Parts 57 and 64, so things like Inheritance Act claims, and also claims in the technology and construction courts relating to adjudication. On the point about litigants in person, you might think, well, actually, this is really helpful, because how often have we seen witness statements from litigants in person that are overly long, really tendentious, don't really address any of the issues. Personally, I don't see, however, that that's going to resolve any of these issues. I think Joel will talk a little bit more about what this actually does achieve in practice, but I can't see how we're going to get around litigants in person not observing the rules, so I don't know that it's going to cure any of those problems. The next question is, when you're looking at the practice direction, what are the key take-homes? What must you do when you're preparing a trial witness statement? So you need to be mindful of the statement of best practice at the appendix to practice direction 57AC, and also any relevant court guide that applies to the place that you're litigating in. So it's not, unfortunately, a one-stop shop for where you can find the answers. You also can't do away with looking in Part 32 and the practice direction to Part 32. The statement of best practice sets out a few key things that you need to be aware of. The first is witness evidence has to be prepared in a way that avoids anything which might alter or influence the witness's memory, and that the witness statement needs to be as short as possible. Another key take home is documents should only be referred to where necessary. And there is now an obligation to list all of the documents that the witness has considered. This was one of the most controversial areas of the practice direction and the statement of best practice. And it's the only area that the implementation group couldn't agree on. The idea behind it was that the court should know up front what the witness might have been stimulated by or influenced by, because showing documents to a witness does lead them. On the one hand, the objection to it was cost, that there might be some adverse inferences that could be drawn, and issues in particular around privileged documents. It's been adopted because there was a test drive of the practice direction, and one of the things that was found from that test drive was that it was found not to increase preparation time significantly. I think we probably need to take that with a little bit of a pinch of salt, given that the test drive consisted only of 4 examples, so not a great pool of cases to draw from. What the implementation group did think is that it was good to focus minds on what documents are actually necessary for proofing. To quote from the implementation group's report, the proper confinement of the proofing exercise by reference to considered advice on evidence is the bigger prize. Bigger by comparison to cost saving is what was meant there. Documents that are to be referred to, however, should only be those for that purpose or when necessary and if relevant, i.e., firstly, if it is to prove or disprove the authenticity of a document or the date of a document. Secondly, to explain that the witness understood a document or particular words or phrases in a certain way when they were sending or receiving or otherwise seeing that document in the past. Or thirdly, to confirm that the witness did not see or saw a document at a relevant time. So quite a limited number of things for when you should be referring to documents. And expressly, witnesses should not be quoting from length from documents or seeking to argue the case, or critically taking the court through documents or setting out a narrative from the documents. I think that is going to be one of the big things that we'll see in terms of changing how we we set out our cases, you know, establishing chronologies, and David's going to talk a little bit more about that later. Another key thing is on important disputed matters of fact, trial witnesses should state how well they recall the matters that they address, and state whether, and if so, how and when their memory has been refreshed by reference to documents, identifying which documents. The preparation of the draft as a whole should involve as few drafts as possible to avoid corrupting recollection. And this then ties in with the last point on the slide, which is how the evidence should be collected, which is ideally via an interview with the witness, where the lawyer should ask open questions as much as possible and shouldn't be asking leading questions in relation to important contentious matters. Lawyers will need to keep a full record of that meeting or interview, however it's done, whether by a contemporaneous note or other durable record. And if it's not prepared in this manner, the witness statement will need to set that out at the beginning. So what the statement of best practice does make clear is that the lawyer's job is really now how you structure, how you lay out, how you scope the witness statement, but content shouldn't go beyond what the record or notes of the interview say. Another key change in the practice direction is you've got to have a certificate of compliance from the witness. You'll see the content of it on the slide, and it's effectively that the witness understands that the statement that they're making is entirely from their own personal knowledge. You're still going to have your statement of truth as set out in CPR 22.1c PD 32, and remember that statement of truth is now enhanced, so you've got to, the witness has got to expressly confirm that they understand that it's a contempt of court to make a false statement. So quite high stakes now for witnesses. You can apply to vary or depart from the requirement to include a certificate of compliance from the witness, and any application should generally be made without notice and will be determined without a hearing. Although that seems slightly strange to me, given that it's probably going to be quite contentious if a party is applying to depart from the practice direction. So I wonder if we might see a number of applications to set aside orders where the court has permitted a party to vary or depart from the requirements to include a statement of compliance. Probably most concerning for legal representatives is the obligation now to have a statement certifying that the legal representative has complied with the practice direction. It has to be signed by a relevant legal representative, which is defined in the practice direction as a legal representative authorised to conduct litigation who has had responsibility for ensuring that the purpose and proper content of the trial witness statement and proper practice in relation to their preparation have been explained to and understood by the witness. And that is emphasised again in the statement of best practice, which says that any witness providing a trial witness statement should have explained to them by the legal representative the purpose and proper content of such a statement and proper practice in relation to its preparation before they're asked to prepare or consider any draft statement, or where practicable before any evidence is obtained by them by interview or otherwise. This should include ensuring that the witness has read and or reading to them the witness confirmation required by PD practice paragraph 4.1 of the practice direction. So this has to be signed unless the statement is made by a litigant in person, or if the court makes an order varying or departing from the requirement to endorse the statement with the certificate. Query when the court is going to give an permission to vary or depart from the requirement to endorse the statement, given that the real purpose behind the new practice direction is for lawyers to take ownership of the consequences of drafting evidence in a manner that isn't the witness's own evidence or the witness's own words. Other issues that I think lawyers need to think about is, firstly, who's going to sign the certificate of compliance? Partners won't be able to unless they've been involved with the process of drafting and explain the requirements of the practice direction to the witness. But are junior solicitors really going to be in a position to do so? Another big question is, how will this impact the involvement of counsel in drafting statements? How can someone at a firm confirm that the preparation of the statement has been in compliance with the practice direction if counsel has been redrafting it? So I think risk management departments are really going to have to think about this carefully, as well as how the bar is involved with the process of preparation of statements. Last, I'm just going to run through very quickly the consequences of non-compliance with the practice direction. The bowling pins on the left-hand corner of the slide are meant to represent a strikeout. So one of the things is that the court might refuse to give or withdraw permission to rely on the statement, or strike out all or part of it. That's always been a possibility, and there have been a number of cases which have talked about that. I don't know that this really happens all that often in practice. I've certainly only experienced it very rarely, that the court strikes out parts of statements or the whole of a statement. But maybe in this brave new world, we'll see it much more often. Another option is an order that the trial witness statement be redrafted in accordance with the practice direction. The third option is an adverse costs order against the non-complying party. We probably would see those two things in conjunction, and or possibly the third having cost consequences, which is an order that a witness gives some or all of their evidence in chief orally. You can only really see that arising if we get to a stage where at trial the judge is not satisfied with the way the witness evidence has been prepared, and it's probably really the most scary for counsel, given, as Joel said, very few of us have extensive experience in giving evidence in chief. Another thing to think about is whether there could be criticism levelled at the supervising partner or firms, especially if it reaches such a level that it could be reported to a regulator, for signing a certificate of compliance when the statement hasn't actually been compliant. Another issue is a failure to endorse a witness statement with a certificate of compliance by the legal representative may result in the witness statement being struck out if there's reason to consider that the party was acting in person in order to avoid there being a certificate of compliance attached to the statement. So one thing that strikes me is, are we going to land up with a slew of satellite litigation about all of this? And how is the court going to determine whether the party was acting in person in order to avoid there being a certificate of compliance attached? How does that interplay with issues of privilege? Certainly the practice direction and the statement of best practice have clarified that the rules of privilege aren't changed. Is this really only going to be an issue when solicitors come off the record? We all know there could be a number of reasons why that happens, which are privileged. I, for my part, can't see advising a client to make any application to challenge on that basis, unless it were a really clear-cut case. Otherwise, you're going to see sorts of the squabbles that you see in wasted cost cases, where the court has come down clearly in favour of the legal representatives being given wide latitude when you can't consider privileged material. I think we also need to think about issues about wasted costs, potential, as I said earlier, potential regulatory action and embarrassment in relation to non-compliance. I'm now going to hand over to David, who's going to talk about some of the practical and tactical issues you might face.
Good morning. Standing back, as Joel's already emphasised, that there were a number of key concerns which have driven these particular changes. Firstly, that witness statements have become over-lawyered in the rather ghastly modern terminology. They were not the witness's own words. Secondly, there was a feeling that the constant drafting and redrafting of statements intended to corrupt witnesses' actual memories on events. statements, and they were being influenced by what the lawyers were putting in their statements and the evidence that they gave was being so influenced. Thirdly, witness statements have become over lengthy, too much reference to and recitation of narrative documents. And fourthly, the process have become too costly. I mean, speaking for myself, this, to my mind, is yet another example of the takeover of the old Chancery Division by the Commercial Court, because this is driven by Commercial Court judges who, many of whom sit in crime, as they sit in the Queen's Bench Division technically, and they'd seen the now still traditional method of examination in chief in criminal trials, and they yearned for the simplicity and relevant brevity that granted. So what this is effectively an injunction to prepare a witness statement as if you were examining in chief. I'm probably one of the few people on this call who's actually done that. I haven't done it for at least 35 years, but I did do it when I was in practice. It's not a process which strikes me that's going to or intended to save costs. It's primarily about giving what the judges refer to as best evidence. And there are, to my mind, a number of areas where it's going to affect us in practice. First is the preparation of witness statements, and that's the key. As solicitors, and it will be almost entirely solicitors, because the definition of relevant legal representative, as Evie's already said, is one who is authorised to conduct litigation. That is a technical phrase within the 2007 Legal Services Act. Barristers can be authorised to conduct litigation, but most of us aren't, and therefore it will be you solicitors who will carry the can for all this. But you will have to prepare for taking statements and think differently. The provisions of the Statement of Best Practice are paragraph 3.10, the interview process, paragraph 3.6, the no documents rule, paragraph 3.8, the few draft as much as possible rule, paragraph 3.13, not go beyond the notes rule. These will mean, and others will mean, that solicitors will have to carefully prepare for the process because it's intended to be done in one or maximum two interviews as if being conducted as an examination in chief. You'll have to have a clear idea of what evidence the witness is likely to be able to give. You'll have to have a clear set of open, non-leading questions to ask the witnesses. You're meant to elicit the evidence by asking those questions in an open and non-leading way. Thirdly, you'll have to have a clear idea of about what documents you will be able to or need to show the witness. And fourthly, you'll have to make arrangements to have the interview recorded, either digitally or in writing or manually. And it will mean, as I say, a different involvement of counsel. Counsel cannot really, it seemed to me, be involved in drafting or redrafting. Here's the witness statement. Well, I'd need to draft this. Why doesn't the witness say X, Y, and Z? Although you may want to take counsel's advice in advance of doing as to what the key issues are relating to the pleadings and the issues in the case. It seems to me that someone will make some money by introducing some training as to how to ask non-leading questions. In other words, to train solicitors as to how to do examinations in chief, which is something that counsel used to be trained to do before the introduction of witness statements. You'll have to prepare a list of questions in advance. And I suppose another thing is thought should be given as to whether witness statements ought to be prepared before the disclosure process takes place. Particularly with witness clients who are witnesses, it may be that documents disclosed in disclosure, which the client will have seen, could be said to have corrupt the witness's memory. Remember that, or to have altered or influenced the witness's memory, and that is something which might need to be considered. So, as costs and cost budgeting is concerned, I'm not sure these changes are going to save any money. That the witness statement production process may be shorter, but it will involve a lot more preparation prior to the interview, and you'll have to sit down with a witness in one or two sessions and have an interview. It seems to me that this can't really, given the certification that's required, it's not really wise to leave it to the most junior assistant solicitor. It may be that senior associates or partners will have to be involved in the process because of the risks of a failure of certification. So it may be that time will be spent differently, but I'm not sure that the costs are going to be saved. And as Simon Monty, Donald Judge Monty said in the talk to the Chancery Division, to the Chancery Bar Association, it's not primarily intended as a cost-saving process, although it's hoped by a side window that will take place. As far as trials are concerned, it will have an effect, I think. It's intended to reduce the scope of cross-examination. If witness statements are shorter and contain only those matters which the witness has personal knowledge, there will, it's hoped, be less material on which clever counsel can mount an attack on the witness's credibility. And however, given that witnesses will not be able in their statements to deal with cross-examination points, I wonder if there might not be some surprises. As I read that, it's no longer possible for a witness to say in a witness statement, I now note that in a particular document, which I didn't see at the time, it is said X, Y, and Z. I deny that's the case. Or I now note that it is said that X, Y, and Z. Well, I deny that. That seems to me is not allowed anymore. All you have to do is give the witness has to set out what they knew at the time and what documents they knew at the time. And they're not allowed to preempt cross-examination by dealing with points that they didn't know at the time, but now know. And that might provide some surprises in cross-examination. However, I'm not sure the cross-examination, the scope may reduce because you've got less tangential material, but at the end of the day, in most trials, certainly in the commercial court and in the business and property court generally, a lot depends on the contemporaneous documentation. And the courts have repeatedly made clear that when it comes to competing oral evidence or clashes of oral evidence, credibility very much depends upon two things. One, is the evidence credible compared to the other known and admitted facts? And secondly, does the evidence coincide with the documents, the contemporaneous documents? And therefore, there will still be the focus on, well, you say X, but look at this letter which was sent at the time. If X had been the case, you would not have said that letter in this case. That's the most effective form of cross-examination. It doesn't happen the way we've just seen in Legally Blonde very often or at all. It's simply chipping away at the witness's credibility by pointing out differences between what they now say occurred on the one hand and what the contemporaneous documents say on the other. So I'm not sure whether you want to follow Tom Cruise in this. That's A Few Good Men, I think, but I'm not sure it'd make a very interesting film. But that still, the basis of cross-examination is going to be the same. So I don't know whether, I mean, one tended not to be allowed much to cross-examine on tangential matters. You might get testy. You might say to a witness, well, look, you say this, your witness statement goes into this particular point on this particular document. You didn't see that document, blah, blah, blah. And the judge will eventually go, yes, Mr. Holland, this has been drafted by the solicitor. Can we move on to points that actually matter? So it may not affect the course of cross-examination terribly. However, one thing that it might do is alter how you refer to documents or deal with documents. You are now no longer allowed to produce in a witness statement a chronological narrative based on the documents, because that's not within the witness's own memory. However, you're now there, well, how do you introduce these documents if you're not going to put them in cross-examination? How do you introduce them? There are a number of existing provisions worth bearing in mind. By CPR 3219, it's provided a party shall be deemed to admit the authenticity of a document disclosed to him unless he serves a notice that has to be proved at trial. So there is a presumption of authenticity, i.e. it's not a forgery, unless until the party, one party or the other says, I want you to prove that because I think it's a forgery. Practice Direction 3227.2 says, all documents contained in bundles which have been agreed shall be admissible at the hearing as evidence of the contents unless the court orders otherwise or a party gives written notice. So again, a document disclosed is deemed to be evidence of its contents unless someone pipes up and says no. The Commercial Court Guide, paragraph J 8.5, says that warns them accordingly, save for documents in respect of which there's been a timely notice to prove authenticity, all documents in the trial bundle will be admissible in evidence without more. So that's the Commercial Court Guide. The Chancery Guide is slightly different, but it provides for parties to agree. You have to agree whether documents being in the bundle, whether the agreement extends no further than agreement to the composition or preparation of the bundles, or includes agreement the documents are authentic, or includes agreement that the documents may be treated as evidence of the facts stated in them. So the Chancery Guide under there, you're meant to expressly agree what the status of the documents are. But you can no longer rely upon a narrative in the witness statement. The question is how then you're going to introduce them to the judge. The Commercial Court Guide says, however, the fact that documents in the trial bundle are admissible in evidence does not mean that all such documents have been adduced in evidence so as to form part of the evidence of the trial. For this to happen, either the parties must agree or the advocates must introduce them. So it's the advocate's job in the Commercial Court, certainly, to draw the court's attention to which documents, they're all admissible, but which documents do you actually rely upon? Now, normally that will be done in the witness statement formally because you'd set it out at rather great length. However, in both the Commercial Court Guide and the Chancery Guide, there are limits to the length of opening skeleton arguments. Secondly, there are limits in both the Commercial Court Guide and the Chancery Guide to the length of opening statements. So the fact remains, how on earth are you going to rely upon, you're not meant to do it in closing speeches, so how do you introduce these documents in evidence? I mean, I, as a matter of practice, always try and do a lengthy cross-reference chronology for my own purposes, because if I'm asked where a document is, I can get the date of the document and find where it's cross-referenced. Also for the judge, sitting as a tribunal, I find it helpful to have one. But also now it seems to me, you will need in a chronology to set out those documents you rely upon in evidence and say so. That you should read this cross-reference chronology and have at the top of your chronology the claimant or the defendant or the party makes clear that the following documents set out in this chronology are relied upon as evidence in this case. That may be a way round it, but it seems to me a number of corollaries, or this number of points. One, parties will have to give thought well in advance of trial as to what documents they want to challenge the contents of, and let the other side know and the court know well in advance. Secondly, skeleton arguments will have specifically to refer to any controversial documents and flag up why they're controversial. Three, as I've said, I think there'll be even greater need to provide a cross-reference chronology with a statement to the effect that you intend to rely upon either certain of these documents or all of them. Oral openings may have to become longer because you may then have to take the judge to the particular documents that are going to be an issue which you rely upon. And parties will have to cooperate in advance of the trial and either agree the relevant documents or identify those documents which are not agreed. Now, it may be that some parties, some solicitors, some parties particularly, are quite happy to cooperate. Many of the parties for whom I act for and against are not happy to cooperate, and they'd rather see costs and time spent by the other side in seeking to persuade the court one way or the other than agree anything. I know parties who, if what the other party said today was Thursday, the 6th of May, would invite them to prove that to the court and not agree it. So finally, so far as Part 8 claims are concerned, this practice direction does apply to Part 8 claims, and it seems to me slightly strange that it does so. As Joel emphasised, the point, and Edie's emphasised, the point of this is to give best evidence. It's to do with the purity of the oral evidence given at trial upon which there is to be cross-examination. However, the whole point of Part 8 is that it's claims that don't require any oral evidence. That's the whole point, as is made clear in CPR Part 8.12a. Part 8 is generally only appropriate in cases where there won't be any dispute of fact. And it seems to me, therefore, that there's nothing wrong with old-style witness statements, because after all, you are compelled Part 8 to provide, the claimant has to provide a witness statement, and there has to be a witness statement served by the defendant in their acknowledgement of service. It may be those would be deemed not to be trial witness statements, or it would deem to be that at the first hearing of the Part 8 claim, the court can give a direction that those statements can stand as evidence despite the fact that they don't comply with the relevant practice direction. There are certain Part 8 claims which have to be produced, so there's certain claims which have to be started by Part 8 and which may involve disputes of fact, and in those cases, well, technically the practice direction applies, so it may be you will have to get an exception to that, or state why in the witness statement you haven't complied with the practice direction, or get a direction, as I've said at the first hearing, that those statements can stand as evidence in chief at any trial, despite the fact that there has been non-compliance with practice direction, or get a direction that fresh witness statements, which are practice direction compliant, are served in advance of any trial. Those are the thoughts that I have, such as they exist, and I think we're now going to do a quiz.
Just a moment before the quiz. Quick point. We realised that we've actually just run over slightly already, so I think we're gonna keep going for about 10 more minutes. But out of respect for all your time, please do feel free to drop off as you wish to do so. This is the final slide, and then we do have a very quick quiz for you, and we'll try and take a couple of the questions that have already come up in the Q&A. But the very final point from me is just that judges have regularly deplored the type of evidence of which many on this webinar complained when asked earlier. And you can see there the quote from the J.D. Wetherspoon case. There's a few questions that we need to think about. How far will all of this be enforceable? A point that's, I think, slightly been made by Evie is that surely the notes, and David, surely the notes and records of interviews and earlier drafts will all remain privileged. I would usually treat proofs of evidence, the notes of the initial interview and all of that, etc., as privileged. And it's only the final signed version that would be disclosable. How I think Evie pointed is that makes it quite difficult for us to understand whether or not solicitors or the legal representatives have complied. A lot of this is entirely contingent on the certificates of compliance. Another issue is, how far will parties go without doing the iterative process of polishing drafts and asking clarifying questions? And the idea is perhaps that this will reduce cross-examination in time. But just going back to David, but does this actually require more time in opening, closing, and potentially an examination in chief? Not sure we have all the answers for you on those points at this stage, but at this point we'd like to turn over to you for a very quick quiz. So if we could go back to poll EV, we're going to play a very quick blitz round of whose witness is it anyway? And so we've got 6 questions. Very quick, you can have 10 seconds to answer the questions, and we'll be able to see how we're all doing. The quicker you answer the questions, the more points that you get. So if we could switch straight over to the first question. So which one of these does not affect whether the practice direction applies to the witness statement? 4 options from now. There we are. So the date the witness statement was signed, the date the claim was issued, the types of proceedings, or the court where the trial is being heard. And time's up. There we are. Obviously, the correct answer, the date the claim was issued. Next slide. And there we are. We can see Bonnie Matthews, and actually a lot of people there. 6 people really crushing it out, getting the 4,000 points straight out of the bat. So next question. Does the practice direction differentiate between represented and unrepresented parties? I believe Evie made this point. Yes, no, it's too late, can't really remember. That's it. Of course, the correct answer is yes, it does.
Probably a bit of an unfair question in some ways, because it does in some ways and it doesn't in others.
And they're actually very, very minor differences, but yes. So let's see what the leaderboard is saying. CJM and Josh there, really pulling it out ahead. 4 more questions. Which of these is not a consequence of non-compliance? This is covered by Evie as well. An order that the witness statement to be redrafted, order a witness to give some or all of their evidence in chief orally, an adverse costs order, or the witness themselves faces contempt of court proceedings. Time's up. Great. Of course, we don't think anybody's going to potentially be sent to jail for failing to comply, but all the others are potential sanctions for non-compliance. Josh, absolutely killing it here. Next question. Which of these is incorrect? The witness statement must. I don't think I can read all that out in 10 seconds, but it's all up there. Time's up. Of course, the correct answer. The whole point here is to avoid quoting from documents and avoiding just providing a narrative of documents. Josh cannot be unseated there. Final 2 questions. Where necessary, this is not a reason for a trial witness statement to refer to documents. You may remember the next slide, the practice direction explicitly lists the reasons for reference to documents. As the answers get longer, I guess I don't think I can read them out in 10 seconds. Okay, next slide. You shouldn't be referring to a document simply to highlight an issue between the parties as to what the document means or shows, which is probably quite different from how a number of us have seen documents referred to in witness statements currently. And back to the leaderboard before we get to the final question. Is Josh still up there? Nope, Josh has been unseated there by N. Ledyard. Brilliant. And then final question. Hope you're all enjoying this as much as I am. Which of these is Netflix's biggest series ever based off of the highest viewer numbers in the first month? We've thought, since we've all been in lockdown, it'd be appropriate, obviously, to include a Netflix type question. And there's 4 options there: Stranger Things, Bridgerton, Money Heist, Married at First Sight Australia, and You. And time's up. And really to bring it into the win, let's see if Josh crept up there. Of course, it's Bridgerton, a show I personally enjoyed. Oh, no, Josh did not maintain N. Ledyard for the win. Well done, absolutely brilliant. And that absolutely concludes the quiz. And whose witness is it anyway? So at this point, again, do please feel free to drop off. Given
we've just asked 2 brief questions, and then because I'm conscious of the time of people. Someone asked, does the new practice direction apply to any county courts outside the Central London County Court? Evie, does it?
It only applies to those that are district registries. So Bristol, Birmingham, Leeds, Liverpool, Manchester, Newcastle, Cardiff. But if you're issuing in the High Court, the business and property courts there, so not county court proceedings anywhere other than Central London.
Okay. And secondly, will the practice direction apply to all lease renewal proceedings under the 54 Act?
I would have thought if it were in Central London, yes. But otherwise, if it were in the county court, no. I mean, what do you think, David?
I don't think it will. I mean, it applies to business and property courts, which is technically the High Court. It doesn't apply technically in any county court unless it's the Central London. Central London County Court, the business and property list will adopt it and expect you to comply with it, but otherwise, no. Well, ladies and gentlemen, look, thank you very much indeed. If you have any further questions, please feel free to ask us separately. It's been great having you, and I hope you have enjoyed it. Thank you very much indeed. Good day.